Andrew Show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the principal of Feldstein Family Law Group. We have offices in Ontario, located in Markham, Vaughan, Mississauga, and Oakville. And we practice exclusively in the area of family law in the province of Ontario. Today, we are joined by our special guest, Adam Zweig. Adam is here today to discuss the topic of starting a family business with your spouse and the accompanying benefits and pitfalls. Adam is an associate at Landy Marr Kats LLP, a prominent civil litigation firm based in Toronto. And Adam's practice focuses on commercial litigation, which involves him tackling real estate disputes, business and contractual disputes, as well as construction lien disputes. And I should add that Adam and I regularly will work together where we may call and ask questions about some files, and we work on some files together. So I find him to be very knowledgeable and have been very pleased with his work. So without further ado, thank you for joining us tonight, Adam.
Thank you very much, Andrew. I appreciate the introduction, and I'm very happy to be here. The topic of the day is, a really interesting one. And there is some really interesting crossover, as you know, with the things that, you might see in your firm's practice, handling all things family. And I see, often dealing with business disputes and shareholder disputes. So there is a really interesting opportunity for crossover. And you're certainly right that we've had some interesting conversations on files that have some crossover. So I really do appreciate your time. I'm very happy to be discussing this topic, and I really look forward to it. So I'm happy to jump right in, and go ahead.
I'm going to start with being the pessimist of a family law lawyer. And if I was at a cocktail party and somebody says to me, "I'm thinking of starting a business with my spouse," and they say, "What do you think of it, Andrew?" I have a very simple answer. One word. Don't. That's the backdrop I come with, because I think of all the drama and challenges and difficulty that happen to people who are separated and aren't in business together. And contrast that now, adding that additional layer of being in business together and having to have that layer of what do you do with a business if you're separated. So I say that to everybody, but not everyone asks me before they start a business whether they should do it with their spouse. Not everybody is going to agree with me on that. And a lot of people are in that position. So, Adam, in your experience, I'm going to ask you, what are the common issues and disputes that arise regarding family businesses in these settings?
Yeah, I'd like to think I'm a little bit more of an optimist. But the truth is that, in my practice dealing with litigation, I tend to see things when things aren't going well, as opposed to when things are, right? So the benefits piece to the starting of a new business, it might be a corporate solicitor who gets to see the new venture, new partnership. So I too, the majority of my practice and seeing the interactions between families who start businesses is typically when things aren't going so well. And I think a common issue for spouses going into business and other family members, is the lack of necessity for formal requirements at the beginning, because you trust people and you trust your family and your spouse in a way that you might not trust a third party you're going into business with. So at the beginning of said business, you're bright-eyed, you're excited, you're looking forward to setting things up. You might not set up the internal workings and the contracts and the paperwork that might protect you later on if things aren't going so well. So the first thing that I definitely see common is that when family starts a business together, spouses in particular, in a small business in Ontario, the formalities often are missed at the beginning, not thinking that there might be problems later on. That's not unique necessarily to family starting a business. It could be anybody, but the more you know someone, the more you trust them, and the more you think that you'll be able to work through issues that touch over a business later on. So that's certainly the first thing that I think is a common issue, is lack of setting up the formalities that might protect someone later on, tell the people, the shareholders, what to do, how to do it. Yeah.
Well, it's interesting you talk about formalities because I think you're entirely right. People go, they incorporate a company, whether they ever properly organize it or not, give thought to it. And I would say what I see as one of the problems, people will frequently go to the corporate lawyer that's their real estate lawyer who's a general practitioner, and they just, without any thought, go and incorporate a company and say, do it 50-50 because the accountant said for tax reasons it's a good idea. Problem is, nobody's thought about family law reasons when there's a breakup. And I think what Adam would say is if you did it the right way, you would do a shareholders agreement, you'd have the company properly organized. And the part of the right way of doing it with a shareholders agreement would be saying, what happens if these two shareholders can't get along? How do we break up this partnership if it happens? Because I know in corporate law, probably the most important question when you create a business with partners is, how do you deal with the breakup of that partnership? I think, Adam, were you able to hear my question? I think you got frozen there for a moment.
Sorry, I missed the last piece of the question there, Andrew.
Okay, I believe the most important question corporate lawyers usually have when doing up a shareholders agreement is going to be how to deal with the breakup of the partnership.
Yeah, I think that, again, not being a corporate solicitor, I don't tend to draft shareholders agreements, but I definitely have spent time interpreting them or trying to really interpret what the intentions of the parties were in absence of the shareholders agreement. But yes, a shareholders agreement typically will talk about how shares could be sold, distributed, transferred, bought back, bought out, liquidated when a business is looking to move on and when the shareholders can't be in business anymore. And that happens all too often when the shareholders are 50-50 spouses who are going through a separation or divorce proceedings. And, hindsight always tends to be 20/20 and thinking, if only I had that agreement that, would tell me exactly what to do, how we can resolve the disputes in the corporate context, it wouldn't necessarily be brought into the family, the family litigation or the family proceedings. Yeah.
Well, one of the things that I've been thinking of, and I haven't had the opportunity to argue it yet, is whether there's more than two partners. It could be a husband and wife or partners with other people they're in business together, or it could just be the husband and wife. But if you look at the Family Law Act, it has something in it that's defined as a domestic contract. And it says, and I'm paraphrasing it, I don't have the wording right in front of me, but it talks about a contract that deals with financial provisions between two spouses, basically. And I've often thought that to me means if it's a shareholders agreement, well, that deals with the financial consequences between two spouses if they're both spouses. And one of the things that I don't believe, and I know you don't draft these agreements, but I don't believe a corporate commercial lawyer, I believe they're going to tell each spouse to go get independent legal advice for the review of the shareholders agreement. But the Family Law Act requires before a domestic contract is executed for there to be full, frank financial disclosure. And I query that that's ever done. And I say that because I'll give an example. You take a shotgun provision that goes into a shareholders agreement. And for those that don't know what a shotgun is, basically it's a very hard and fast way if two partners can't get along to decide who's going to keep the company. In that situation, partner A will say, I'll pay $1 million for the company. And partner B has a certain number of days to say, I actually will take that and I can buy you out for $1 million or I'll sell to you for $1 million. But the reason why financial disclosure becomes so important is if my partner has a net worth of $25 million and I have a net worth of $50,000, my partner can exercise the shotgun and know enough to buy me out. And you may think about it that there's going to be issues from a family law context, and there will be, but that could lead to the agreement being set aside because somebody may say they're missing out on certain opportunities. So I would say that people who may be watching the show and thinking about this and they want to go get a shareholders agreement, which I would entirely encourage, I would actually say there needs to be discussion with family law counsel at the same time. And we don't deal with marriage contracts, quite frankly, and there should be financial disclosure at the same time so that you're in compliant with the requirements for it to be a domestic contract under the Family Law Act.
Yeah, I mean, that's very interesting. I have not really, to your point about this being a query, I haven't thought about the idea of a shareholders agreement with spouses being under the ambit of a domestic contract. And to touch on your point about shotgun clauses in general, from an entirely business perspective, there is a hesitation often by people who are starting a business to think about how much a business could be worth at the end, or whether they want to be in a situation where they are hamstringed by a shotgun clause. And it does come down to the way you think the business could run, even if things don't go well. Is it the kind of business where you may have access to liquid capital to satisfy a shotgun clause, right? Most small businesses, or many small businesses in certain industries, may be worth a certain amount of money, but that doesn't mean that they have half of that money on hand ready to facilitate a buyout. And it's these types of things that, come into play, certainly, when there's a family dispute or, litigation coming into play, is the availability of funds to satisfy a shotgun clause, in an agreement. So it is interesting, and I really haven't thought too much about whether the Family Law Act and it being a domestic contract, plays in. But it's a really interesting point.
Well, I know it's a point I hope to have the opportunity, in a sense, one day to argue it, because I'd like to see the issue adjudicated. But it's something that I would be concerned about when I'm drafting, if I was drafting a shareholders agreement. I probably haven't done one in 25 years, and I don't plan on doing one again. But one of the other things people need to realize when you decide to make your spouse a partner in the business is there's some significant differences from a family law perspective. For the purposes of equalization of net family property, we look at the date of separation, and we call that the valuation date for valuing assets. And that means you crystallize a date. So if you separate on January 1st, 2021, that's the date your business is going to be valued. But if you're joint owners, or you both have the same number of shares, it's a constant moving target. So if the business is going up in value, you're sharing at that. And if it goes down in value, you're sharing it. But here's the other thing I pose for people. I think of my own separation, maybe too often, I don't know. But I picture that I own the real estate of my office. And if I had made my former spouse a shareholder in the company that owns the real estate, how much would I like it if I came to work as a separated spouse and I didn't have the formalities of a lease, so which means, in essence, I'm month to month, and my ex says, well, I own the real estate. Here's my office right next to yours now. And I can sit here and I can see what goes on, and I can listen to everything that goes on. That's a lot of conflict. And it'll take a lot of money to deal with that problem and how to break up that conflict. So you really need to ask yourself, what is the reason that you want to put your spouse in? What does each spouse bring? Because I'm sure Adam will tell you, in business, sometimes you see two spouses get together in a business, and they each have great talents that together makes for a wonderful business. Somebody is great on the management side of running the business, and another person is great on the production side or sales side. And they actually make a fabulous team and don't interact that much. Sometimes those partnerships can coexist after separation, versus the one where I see quite often is one spouse is the bookkeeper and the other spouse is really the entire business. And then post-separation, they're upset because the spouse who does bookkeeping for 5 hours a week is busy writing checks out of the bank account for themselves. And I'm sure you've probably seen some of that.
I certainly have. And, you raise a very interesting point about, whether a shared family business is indeed shared. And that's one of the other benefits of a shareholders agreement and papering your business as if you don't necessarily assume that all is going to go well. Because you may have one spouse who's the bookkeeper, you may have one spouse who runs the management side of things, runs the finances, runs the accounting. And there seems to be a question when things aren't going well as to who is integral to the business, who really is the brains of the operation, or can any one person be replaced? Was it a partnership that was predicated on the cooperation of these two people? Or was it just an opportunity for one spouse to maybe wet their beak and contribute, not on a 50-50, basis, but maybe just a chance to, feel as though they're contributing to the business or the thing that's helping the family with their income. And this is again where a lack of formalities kind of takes its toll at the end, because trying to go back and decide, who really was the person who's making the decisions that help keep the business afloat will dictate, to a court or to whoever, whose grievances and whose opinions should be valued. Yeah.
Well, you look at it and you say, I'm going to give different examples. So I'm going to start with the business that I'll call more traditional. One spouse does 90% of the work. It's really their business, and the other spouse is a bookkeeper. And they went to the accountant who said, well, it'll be a great idea that you're both on there because it's easier for me to income split for you. Now, CRA has done things to stop that to a certain extent. And if you ever sell the business, you're both going to share in the capital gains exemption. So people are thinking, great, one day I'm going to share in the sale of this business. I'm going to get all this tax free. I would say to people, depending on the business you're in, ask the accountant how many times they've actually seen the business sold for the amount that's going to exceed the capital gains exemption. It doesn't happen that often. You need certain kinds of business to even have that opportunity to gain that traction. So that's number one. Number two, at some point, when you have the other spouse who is that bookkeeper person, they're going to be bought out. That's going to happen. But the problem now is you've created that moving target. You're giving them access to things that you may not want to give them access. And there's a lot of headaches that you're giving up because you gave that spouse those rights. So I would say to that person, you don't want that spouse as your shareholder. You really don't. If it's about income splitting, then pay them a fair wage, because that's all you're supposed to do for CRA purposes. The only place where I really say the total opposite, where they both should be shareholders and directors and officers, and this is really, it's not good for creditor protection purposes, what I'm going to say, but I think of the ones who are the renovators and contractors and cash business. The one that I've often seen happens in that scenario is the reverse. When say the husband, I'm being stereotypical here, but I'll say it anyways. The husband is a general contractor. He does a bunch of renovations. He's doing a lot of cash. He's not reporting his income to CRA. And when he's the sole director and officer and shareholder, he's always nervous. My ex is going to report me to CRA. Always in their mind. I'm going to get reported. I'm going to get in trouble. But the beauty of it is, if they actually made their spouse a director and officer alongside with them, then the former spouse now is on the hook the same as they are. And there's nothing better than keeping somebody honest other than a mutual path of destruction. So in those scenarios, it's actually a great thing to do. That's my viewpoint. I don't know what you think.
Yeah, no, I think it certainly can be beneficial for certain businesses, right? Businesses where creditor risk is a real thing, incorporating sharing the share ownership, sharing the director ownership for liability purposes can be useful. But I think one of the things that you kind of said in your examples, which I tend to agree with, is that if spouses are intending to partner on a business because they intend to be contributing in some level of an equal way, then it does make sense to own shares and incorporate and divide on that basis. But if the purpose is strictly for tax implications, you are also correct in thinking that many times the tax benefits don't outweigh the complications that then arise when someone owns 50% of what is, we'll call effectively someone else's business. And, it would take heed to think long-term of people like, am I really partnering with my spouse in this business, or am I trying to capitalize on potential tax breaks and, move some liability around? And if it's the former, then great, knowing that there may be a separation or divorce in a marriage's future, you both should have equal say in the business as a separate concept. But if it's the latter and it really isn't, the division of the shares at the beginning is, we'll call it the on paper approach, then, maybe think twice, because if there is a dispute later on, it becomes much harder to deal with when you have equal ownership interest in a company. And that's, I've said this to clients a number of times, which is that, while there is remedies under the corporate statutes regarding the way shareholders treat each other, there isn't a law that says that no matter what happens, someone is entitled to a buyout. And it's a little bit different, I guess, in thinking about how that affects equalization, which is that, under the Family Law Act, property will be equalized. Not necessarily the case from a corporate side that just because, one person, let's say, is more dominant in the business, that, the court will insist that someone be bought out. Not always the case.
The court can impose a buyout of a business in the family law context. It will usually happen, though, from the perspective of one person is really the driving force behind the business. And you also have to be realistic. Two people may be equally important to the functioning of a business, but the business can also be in a very unique industry where one person who is the face of the business can't be replaced, and the other person is just really good on the administrative operation side. And that's probably a person that could be more easily replaced than being the creative side of the business. And sometimes people will be able to successfully stay on together, but you can imagine the conflict that happens too when two spouses are at war and sharing a business, which takes me to the next question that some clients come and ask. And as a family law lawyer, we don't do it that often, but you talked about corporate law. And I believe under the OBCA, which is the Ontario Business Corporation Act, and probably under the CBCA, being the Canadian Business Corporations Act, there's something called an oppression remedy. And what does that mean?
Yeah, that's right, Andrew. And it comes up a lot in shareholder disputes, particularly when you don't have the benefit of what we talked about earlier, a shareholders agreement that might dictate some answers to things. The corporate oppression remedy under our business statutes effectively is a catch-all that allows a shareholder or a director or an interested person to make an application to the court for redress when they can show that their interests are not being fairly regarded or being treated in an oppressive manner. And it sounds like a easy thing to figure out, have I been treated unfairly? There's a lot of law and a lot of cases that distinguish between, what might be fair because, you own a majority of the company versus, what is really unfair, even though you do own the majority of the company. So the example that I give to people in thinking about corporate oppression is, let's say you have a company that's owned 75% by one person, 25% by another. Well, it would be a classic definition of oppression if the 75% owner voted to only pay themselves any dividends rather than the 25% owner. That would be oppressive to a minority interest, even though the 75% owner, in theory, does have majority rule and can make a decision for some things not covered by, a shareholders agreement. The majority owner probably is going to be able to vote on which color pencils the office uses. Things like that are more trivial or don't affect someone's shares. The OBCA also usually looks at majority rule in absence of a shareholders agreement that talks about voting rights. But the oppression remedy is a basis where people, particularly minority shareholders, can bring a court proceeding to have the court look at all the facts and circumstances as to whether their grievances are actionable and whether the court should intervene in business and in business decisions or not. And it's a very, factual inquiry, and it can be very broad. And the remedies that the court might have in such a scenario are also very broad. To your point, how the family courts might order a buyout. The court might order a buyout as well. They might order some rectification of the paperwork, given certain, people's not being given access to documents or financials or things of that nature. And it is a very powerful tool to resolve corporate disputes. But usually when you've gone that far, it's more than just things are unfair. It's things are unfair that really hurt, my interest as a shareholder.
And going off the top of my head, I can't remember this case, but there's examples in the family law context of people playing games with, issuing dividends and doing things to affect a minority shareholder. An example could be trying to issue a whole class of new voting shares to reduce one side's interest in the shares. So somebody gets this great idea. You know what? I have 51 shares. My former spouse has 49 shares. I'm going to call a shareholders meeting, and hopefully maybe she doesn't show up, and I'll issue myself 100,000 new shares of a different class that are all voting. So now she's irrelevant. I tend to think, and I remember reading one case where the courts did something like that because the wife was a minority shareholder with the husband and his friends. So you get certain things that can happen that oppression can be involved in. And then there's something else which people don't necessarily think about that often. But when you're a director and officer of a company, you're a fiduciary to the company. But when you're spouses, you also have a fiduciary duty to your spouse. And that can lead to the context of how you behave within the business and what you're trying to do. Are there secret deals going on with partners that you're not telling them about? And to me, it's all about transparency when you're in that kind of situation. And I would say if a client asks me, well, how do I know if something is right or wrong? I frequently will say to somebody, how would you feel if what you just did was on the front page of a newspaper or something that's popular that people read, I guess something that goes viral? Would you be proud of what it is, or would you be embarrassed by it? If it's embarrassed, you probably know your answer to whether it would be a breach of a fiduciary duty or something that would attract oppression.
Yeah. And, one of the problems with figuring out what is oppression or, what might be a decision that the majority versus a minority should make is the scenario we were talking about earlier, which is when it's 50-50, right? When companies are owned by two people 50-50, you don't have that automatic majority rule concept. And, it's, in some ways a 50-50 ownership of a company can result in, an automatic deadlock when two people want to do different things in a company. And it might be the case that the reason why spouses in particular will open corporations when they go into business together 50-50 is based on the principles of how property, could be divided in the event of a separation in any event. Or maybe it's reflective of, don't know, but 50-50 in particular leads to greater issues when a company is not papered with, clear divisions of power. Because, sorry,
No. Well, what I was going to say is you're right about the 50-50. The example of where oppression remedy and fiduciary duties become more important is a situation where, I'll give an example, two couples decide to start a business together and they're friends. And the separation happens, and sometimes the separation happens where one person was a cheater. So now the other two people rally around the one who they perceive as the innocent victim, especially if they have the client list. There's a perfect example of where the oppression may happen when you have four shareholders that each have 25%, and those three shareholders are angry at the fourth shareholder, and they may create that other class of shares or do things to try and minimize that person's role. And that's where I think things like oppression, breach of fiduciary duty may play a role, because I've seen lots of situations where you have two couples as a partner, or even, I remember when I first started doing law, I had a client that was in corporate commercial work, and it was a husband and wife who were partners with other people. And you would think originally the husband and wife were always aligned. Eventually they weren't.
Yeah, that's that goes back to the pitfalls, right? When things are going well in business, you don't necessarily need to put everything to a vote or think about whether an action is going to be oppressive or not. But the newspaper test is a good indication. But sometimes what might be oppressive isn't so apparent that it would look so bad on the newspaper. Oppressive and the oppression remedy in the corporate context also looks at something that will unfairly disregard the interests of the shareholder. And, figuring out what's fair is a challenge for the courts always. But, is it fair that the majority have control over some things? Yes. Is it fair that the majority, again, be able to vote that or do something that's only in their interest? Like, as your example, issue 100,000 new shares? I mean, no. It's all the stuff in between that happens in practice, and where me as litigation counsel really kind of dig in and look for those middle grounds and try to see, how a court might look at some steps that aren't so clear on their face, but do need to be resolved because, a shared business is like any business that, the stand to gain by its continued operation, almost always more than when it's wound up and dissolved. So sometimes the oppression remedy can be a tool that actually helps a business in its future rather than guarantees its end. And those are the cases that I prefer working on because, you might, the goals are positive as opposed to, let's say, a goal to weaponize a corporation or use it, as leverage in, matrimonial proceedings.
Well, Adam, it's been a fascinating discussion tonight, and I've really enjoyed it. And again, thank you for joining us tonight on the Ask Andrew show. Our next show is going to be on July 21st. If you have any questions or ideas for future shows, please email them to us at info@feldsteinfamilylaw.com. And thank you for watching and have a great evening.
Thank you very much.